Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we're talking about the administration of an estate in New Jersey where there's no will. It's foolish not to have a will because if there's no will, the process becomes much more complicated. So, for example, if there's four children, all the children must agree upon who's the administrator. The person who is not going to be the administrator. The other ones have to sign what's called a renunciation for administration, typically prepared by the attorney, and then it has to be filed with the county surrogate's office and paid a fee. The person then who wants to become the administrator, they typically have an attorney. The attorney will forward to the surrogate's office the information sheet, information on the estate, the amount of the assets, who all the beneficiaries are, since there's no will, anyone that would inherit, and then some surrogates will send the paperwork to the attorney to sign and then forward in. Other surrogates' office require the person to come in. Thereafter, the person who's the administrator has to pay for what's called a bond, a surety bond, with a different bonding company. And the rates are the same in Middlesex County. People often use Pavis McCormick or Baruch Agency. But the process becomes much more complicated. At the end of the estate, then the attorney prepares what's called a release and refunding bond, which has to be signed by all of the beneficiaries and then has to be filed with the county surrogate together with paying a fee. If anyone does not sign the release and refunding bond after receiving the informal accounting from the administrator, then there has to be a formal complaint or to show cause in the county. There has to be a formal accounting done, which is a very complicated procedure. And then the surrogate's office will audit it. The beneficiaries can file exceptions, but that delays everyone getting all their money by 6 months, 16 months, whatever, depending upon the county. That's why, again, it's important to have a will, because the process becomes much more much more difficult when someone doesn't have a will, having to go through these additional steps of the surety bond, renunciations, and filing of the release or refunding bond. For more information on the administration of the estate, visit and read the articles on website njlaws.com. And for representation, contact Kenneth Vercammen's office in Edison, 732-572-0500. Thank you.